Hey guys. Hey guys, what's going on? Happy Tuesday. What's going on, everybody? Okay, I was just checking my soup. Okay, let's get into the hearing because we don't really have anything to wait for. The hearing's actually already over, so it's kind of interesting. I remember seeing his lawyer. So this is the hearing for Jamell Demons, aka Melly. Um, this is a murder of a childhood friend. There's something interesting going on with his lawyer too. Ravon Liberty, she's under investigation regarding something about witness tampering, but I also remember she was in like a contentious custody battle with her ex-husband or her husband. And I remember seeing some body cam video with her, like something weird was going on, but she's under investigation regarding witness tampering. There's this is interesting. So let's get into it. Hey everybody. Honey, say that. Do I have my rings? Okay. Mimi and Blue Sapphire got here 1, 2, 3 first. Hey everybody, what's going on? Okay, let's get into it. Let's see how we're gonna do this. Okay. Give me just a second, guys. Let me make this big. I feel like okay, here we go. Y'all, I was like, I am on my schedule today. I'm getting that business. Okay. Hey, everybody. We had fun over on Love Lies and Lace Fronts this morning. If you missed it, go check it out. There's a lot of stuff going on these YouTube streets. It's like, what is really going on out here? Okay. I'm so glad to just be a spectator. Can I just say, shouts out to being just a fly on the wall. I'm so cool with being just a fly on the wall, guys. I really am. I'm not even gonna lie to you. I am so cool with not being involved. Okay. Because that stuff going on is a lot. Okay, let's get into this. I feel like I need to move my screen over, but we'll get into it. All right, so the beginning part of this is really just chitter chatter in the courtroom. This judge seems to be a little bit annoyed. The judge, I guess we'll just let it start playing. The judge is really not playing with anybody. There's just a lot going on. While we're waiting for this to get started, which we can advance, but I just want to tell you what's really going on here because you're going to hear something about them wanting to the judge is going to want to talk to Jamell Demons, aka Melly, about his lawyer. This is Miss Ravon. Wait, that's not her. That is her, Ravon Liberty. Okay. Ma'am is and she's under investigation for potential witness tampering. I'm going to have to read you this article and see what's going on. If you see, I'm going to have to pull the body cam video when she was going at it with her husband. The guy said she is meant, look, we'll talk about it after this. I don't want to inject all of that into this, but ma'am had a divorce situation going on. This doesn't have anything to do with that. I just remember her. But sir has a team of lawyers. I believe this is round 2 for this situation. I think they said the first one ended in mistrial. So they're saying, okay, so this is the recap from yesterday. I'm reading this article. A Broward judge was set to consider a flurry of motions Monday in the case of South Florida rapper YNW Melly, but the hearing came to a stop when discussions over the investigation into his lead defense attorney, Ravon Liberty, came up. So maybe we do need to go back and listen to that. We'll go back to that after we do this. Let's do this first. The rapper was back in court for hearing. The rapper was back in court for a hearing on Tuesday. Melly, whose real name is Jamell Demons, walked into court wearing red maximum custody jumpsuit. Demons is part of the music collective that included two different childhood friends who rapped under the name YNW Juvie and Sack Chaser. Uh, duh, 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 duh. Okay. He is accused of killing them both after a late night recording session and making it look like a drive-by shooting. He's been in custody since his arrest in February 2019. His case first garnered attention for the treacherous storyline recounted in court, his antics, and also his rising success. His biggest hit was called Murder on My Mind, and he boasted a track featuring Kanye West. Prosecutors confirmed Monday that Broward Sheriff's Office is investigating Liberty, that's his lawyer. Y'all. I'm like, why am I so low? Okay. Prosecutors confirmed Monday that Broward Sheriff's Office is investigating Liberty tied to Demon's tampering with evidence charge in 2023. Demon's other attorney questioned this investigation into Liberty and suggested this could delay his double murder retrial because Demons may decide to remove her from the case and start fresh with new counsel. Is she under investigation? The answer is yes, said Broward County Judge Martin Fine. The only other question Mr. Demons has to decide, does he want to go forward with her or does he want a conflict-free counsel, which he is certainly entitled to. Liberty was not in court Monday due to bad weather delaying her flight. The probe is open and ongoing, and no charges were filed against her at this time. The judge determined little could be done to move forward with the case until the defense knows more about the investigation involving her, and she is in court to argue motions. The hearing was resent to Tuesday morning. Demon's double murder retrial is currently set to start in September. His first trial ended in a mistrial in summer of 23. Okay. So that's his lead attorney talking to him right there. And then there's the two other guys. Let's advance. So they said his whole family was in court. Y'all were funny. I was reading the comments and I said something about he was smiling at his family and showing all his veneers, and y'all thought that was funny. Anyway, okay, let's hear what the judge has to say, and then we'll go back to yesterday. Yesterday's, I don't think, lasted very long. And then I've got, hold on a second. Then I've got this. I've got his booking report, or his, they called it arrest paperwork. But it's the booking report. And it's 27 pages and it goes through many, 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 many different things. So we can scroll through that. It's just a lot. So let's get into it. I said, let me go ahead and get here now so we can get through as much as possible. I'm still trying to figure out, I did a different setup. So I'm still like, if I'm on camera, trying to figure out like where, because I feel like I have to kind of look up a little bit. But just bear with me if I'm looking here and there, because I'm looking at my screens rather than looking at you guys. I guess if I'm looking like this, but at this eye level, I'm observing the board. So just bear with me. I'm not ignoring you guys. I just, if I look like this, I can't see what you're seeing because I'm only looking at my screen. Okay. Hey everybody. So you guys can hear me. Everything is good. Can I get some ones in the chat? Because I'm not on playback. Let me go to my playback screen so I can see if you guys can hear me. I'm assuming if you couldn't hear me, I would be getting some red flags. Okay. All right. So we're good. We're good. Okay. My screen's pulling up. Okay. Y'all, okay, let's get into it. If you guys missed last night, we did do a a Cobb County visit. I don't even want to talk about it. Those two are off their rocker. The Ricky Smiley lunchtime yesterday was so funny. But I think we might be able to get through all of what we want to get through before I need to go pick Farah up from school. So let's get into it. Okay. All right, let's go. I feel like I should move my screen over here so I can see better.
Just so happens. Okay.
All right. Are we all caught up? If you come in, if someone comes in, just tell them to scroll the bar back because look at all that paperwork he has. I'm going to find the video too with his lawyer and what happened with her and her husband. We'll play that another time.
Good. Okay, let me go back on the record. This is State versus Jamell Demons, 19-1872 CF10A. I've got Ms. Bucklow, Ms. Collins, Mr. Griffiths present for the state. I've got Ms. Liberty, Mr. Abelstein, Mr. Aronson, Mr. Benjamin, present from Mr. Demons, who likewise is present. We're not waiting for Mr. Catanza.
We are not waiting for his presence.
Okay. Okay, so this is just a continuation of yesterday. I did get, and I read, as well as the authority cited therein, the state's motion for rehearing and reconsideration of the defendant's or tenant's motion to compel disclosure of the Apple search warrant related to attorney Ravon Liberty. I don't know that I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit. Ms. Collins, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I sign a search warrant for someone's home and BSO goes to their home and executes the search warrant and they're there, they give them a copy of the search warrant.
Correct.
Upon its
It's
execution.
Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
So they're talking about a search warrant for his lawyer's, I guess, Apple device. So maybe they think there's some evidence in her phone and there's some back and forth about. So I don't know. I don't know what she did or didn't do. This is very, like, when I heard this morning, I was like, oh, this is really getting juicy now. If they really think that she had something to do with tampering with evidence or tampering with witnesses, this is getting really, really juicy. And I'm here for it. Had you guys heard about this?
Yeah, that's correct, Judge. Yes.
That's your position?
Yes, Judge.
Okay. Okay, well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today, so you can litigate that as you see fit, but I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date very soon in the future. It's a date in February, which is what I'm looking at. And at that point in time, you're gonna have to come back in here and tell me, and I'm gonna have to have a discussion with Mr. Demons. I'm gonna start that discussion this morning, so he understands that he's the captain of the ship. This is his decision, but he's gonna have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's gonna have to tell me if he wants all of you to continue to be his lawyers or not, or he's gonna have to tell me that he's gonna seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that issue. I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or ruling. I think she's entitled to I think, listen, Mr. Demons is entitled to heightened due process. The state
Yes.
is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now.
Okay.
He is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, the Florida Supreme Court has been very clear on this. He's the captain of the ship.
Absolutely.
He makes this decision. So if there was, again, I'll repeat what I said, I think, to Mr. Aronson yesterday. If you all had some other authority that says, I have some additional power to assist in the fact finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority, or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Devins wants to do. This is completely 100% a decision between himself and his lawyer. I don't have anything to do
We're
with it.
not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. This trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things. If that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea of response. And if I may, just go through the corrections that we saw. It's on number 1, it says the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, so, yeah.
In paragraph number 2, they said that the state disclosed an ongoing investigation to Miss Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed. Paragraph number 5 indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Devins. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information, anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement that regardless of what Mr.
You see how the judge is looking at him? Good morning. Good morning. Good morning. Yes, the female lawyer, Ravon Liberty. That's who's under investigation, but that's also another one of his lawyers. There seems to be a witness tampering. We kind of talked about all of this just a minute ago, but there is a witness tampering or tampering with evidence situation going on. I'm just getting up to speed on some of this. I've seen her before, though. I heard about her when she had her own situation with her own husband that she's estranged from in Florida. There's like a custody situation with the daughter. That's a whole nother thing, but ma'am is interesting. And now to find out that she's under investigation for tampering, that's interesting also. So this isn't going to last very long. We're probably about 30 minutes in. Well, there's about 30 minutes left. And then there's the hearing yesterday where it, I guess the conversation started and it was disclosed that Miss Liberty was under investigation. So, all right. So
Devins wants and is willing to waive the conflict. They believe that Ms. Ravon must get off the case, regardless of that. That's their assertion. They have to prove it. And I want to put the court, the state on notice that they must prove. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to Your Honor's request, Mr. Aronson and I spoke to Mr. Demons. I call him Melly if the court will allow me.
I'd actually prefer that you use.
Mr. Demons?
Yeah.
Fair enough.
Thank you.
Mr. Demons, we discussed the potential of that. And if the court accepts my representation, or the court can inquire from him, he informed us that he doesn't have enough information to make that decision.
You're
And I
talking to
want
me
to
about privileged communication.
Well,
I'm going to talk to Mr. Devens at the conclusion of the hearing this morning, everything that I'm allowed to talk to him about. I want to hear about anything that you all talk about.
I was just willing to profit the state of that fact. And we would, of course, ask the court to deny their motion for rehearing and rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let them come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. And 3.220 is clear on that. Anything that could lead to relevant information must be disclosed. Judge, there is one other matter that we need to go sidebar on.
Okay, well, hold that, pause on that till then. State, is there anything else that you want to tell me today? The only thing I'm going to do is talk to Mr. Demons about the front end of this colloquy, if you will, and then give you a future date, which I'm looking at is February 18th. That's the day before my next trial starts, after the trial that's starting tomorrow. And on Tuesday, February the 18th, what I'm also going to ask each side to do is, if there's any motion pending that you think I can hear that is not interfered with by the pending matters that are up on appeal to 4th DCA, state if you have anything that you want me to hear on February 18th, just file a notice of hearing and identify the motion you want me to hear. Defense, if there's anything else you want me to hear on February the 18th, just file a notice of hearing and identify what it is you want me to hear. I anticipate the murder trial that I'm commencing tomorrow will be done by then. It may not be, but I'm hoping that it is. And if it is, then I'll give you the whole day on February the 18th to address this issue regarding his representation. And if it turns out we can go forward and hear some of these pending matters, then I'll be happy to do that too.
Judge, I can just ask, I know you said file a notice of hearing, if we could have a deadline like by February 1st, so we don't end up in the same position we did this time where it was filed, pre business
Well,
before.
Let's see, we're talking about February 18th. So how about the end of business on February the 7th? How about that?
That's fine,
All
Judge.
right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear. And I'm going to see him February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day and maybe we'll be able to do nothing. I guess that's really going to be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st, just so we have time to pursue the appellate remedies in the meantime. And then I'd also ask that it provided to Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential, privileged, and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redactions have to be made, and then it can be provided to defense.
We would object to that procedure, and they've had a year, over a year, to produce these documents, so it's no surprise. We would ask that to be given to us by the end of tomorrow.
Okay, so listen, over the defense objection, state, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me. A week from today, that's January 14th. End of the day, January the 14th, that comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it as I see fit. I can't imagine there's anything in there I'm gonna redact. I mean, it doesn't matter, the state's free to investigate whoever they want for anything they want. To do this in the midst of a capital case, state, I realize some things are gonna happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case, so. Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So that's just the way it's gonna have to be, but I'll grant your request over the defense objection, at least as to that. Ms. Wilcox can give you a blank order, you can fill it out this morning, I know it's over the defendant's objection, but show them the order, and I'll be happy to sign it. The search warrant comes to me within 1 week,
Yes,
and
Judge.
then I will review it in camera, and then I will distribute it accordingly, as I see fit. State, anything else you want me to do this morning?
The judge.
Defense, besides your matter that you want to talk to me about, sidebar, anything else
Yes,
you want
since
me to
you're
do this
going
morning?
to, in camera, review the search warrant, we would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that, but if you have some competing authority, I'm happy to look at it.
Yes, sir.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery, and we can start discovery again on everything, or are we still under that stay order? Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that, that you wanted to do the things that you can do.
I want to do everything,
I agree with you.
but,
Time is short, but,
but the state is the one that asked for the stay.
well, state, what do you want me to do?
Judge, we need to speak with the Attorney General's office, because we have that stay for a reason with certain things, but we have plenty to do
Outside of that.
outside of that first, so.
Okay,
we have
well, why don't we do the things that we all agree we can do? So the answer to Mr. Anson's question is yes, without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before.
Well,
the
no,
court
we
this
are
year.
objecting to that, Judge.
That was already done by Judge Murphy.
Right, that's already been
Judge
done.
Murphy already lifted the stay.
He
As to-
modified it,
Right, he
so that we
modified
could
it.
do ongoing
Oh,
discovery
okay.
as to things that were not up on appeal.
Again, if one side notices something for February 18th and the other side thinks that that is included in the matters that cannot be handled because it's currently at the 4th District Court of Appeals, I'm sure you will file a written response and let me know that. And I guess I'll have to make a decision whether I agree with you or whether I don't. Defense, besides the matter that you want to talk to me about, anything else?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says that he has to make a decision now because we told him there's a conflict.
I'm not going to ask him any questions. I'm just going to explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not going to ask him any questions. I'm telling him what's coming. Because at some point, he is going to have to tell me what he wants me to do.
And of course, we're going to object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to whether.
I'm not asking his opinion. You're objecting to me talking to your client about his rights?
It depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were going to inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not. Okay, again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa hyphen Sanabria, Sanabria versus State. It's a Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well. I'll quote with the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel, and there's nothing that makes him relinquish this right. So all I'm going to do this morning is explain to Mr. Demons that at some point this is going to be his choice. I'm sure his lawyers will give him their best advice, but this is going to be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow a lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demons, raise your right hand for me. You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Jamell, Maurice, Jim,
How old are you?
25.
How far did you go in school?
I graduated, well, I got my own GED.
You read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Demons, here's the deal. You're, just like any other defendant, you're entitled to have conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay, you with me so far? Okay. So this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yeah.
Or you can likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that? The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yeah.
Okay. Do you have any questions for me about anything that I've said so far?
We have a moment, Your Honor.
Sure. No questions? All right. So, Mr. Jennings, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, Your case is set for trial September the 10th, and that's not that far away. Do you understand that? Okay, your case is going to go to trial on September the 10th. So if you change lawyers, you're gonna get a group of lawyers in place that are gonna have like 7 months to prepare a capital case, okay? So the longer it takes to make this
I'm gonna
decision.
object to what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand the time is of the essence. Do you understand that?
Yes, sir.
Okay. So I'm gonna put them back on the docket, February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's gonna be distributed to the parties will have long since been distributed to the parties. You all can file whatever additional motions you think are appropriate. If there's any motion that the state wants me to hear, we're gonna do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, you're gonna do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th, at the close of business, I will not be hearing it. On Tuesday, February the 18th, Mr. Demon's case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your,
Yes.
all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go.
Okay, so couple questions you guys have. I don't think that these are not court appointed lawyers. Just based off of the judge's statement, if you need a lawyer, I can appoint one for you. You'll fill out an application if we find you meet the criteria, but just doing like a Google search, I mean, he's made some money as a rapper. It's possible a lot of his money could be gone. I don't know what the status of his finances are. But these are I believe that these are paid lawyers. So something interesting. So I just went, so his first case they said ended in a mistrial, right? The first one ended in the first trial ended in a mistrial in 2023. Then sometime in 2023, there was something that happened. I'm scrolling through this right now. Girl, it mentions Rihanna, ASAP Rocky, something, some sort of plot or scheme was happening. Don't quote me, but my God. I'm like, what? What was going on? They were talking about something. So let's so I don't know. And then so in connection with this plot scheme, this time where they were trying to witness tamper. Now the witness that that he's being accused of tampering with, they're saying that maybe he told his mother not to cooperate with law enforcement. And then girl, yeah, a mistrial. Their first trial ended in a mistrial. Now they're coming back again. So this is the lawyer. It's quite possible the state is picking and wants him to, because keep in mind, if this lawyer was litigated him to a mistrial the first time, then maybe it's that she gets him, a verdict of not guilty. Who knows? Maybe they want to try to chip away at his team because, as you can see, his lawyers are representing. They were definitely here and fervently kind of defending, and also their right to have, to represent their client. Let's see, are they going to say anything else? This might be over for the day. So they're off the record, but they're having some conversations. Let's see. So here's all of the lawyers. Let's see. I mean, look, through it, this guy's been in jail now for over 2,000 days. and he's sitting here smiling. Maybe he's, he's probably happy to see his family. He's 25. If anything, when you're 25, hopefully you're resilient. He does have a certain type of look. I know some of you guys are like, he looks this and he looks that. I mean, sir I'm sure has seen better days. Is that some legal mail? They just handed him. All right, there's Miss Liberty. This is Miss Liberty right there, and she's under investigation. Apparently there was a search warrant on her Apple devices. She became aware of it yesterday, so maybe she didn't know, but it sounds like they requested and did some sort of data extraction of her information, her cloud, her whatever. I don't know. Let's go to yesterday's where it actually came out that this was going on. Is this yesterday? An hour ago? What day ago? Okay. This is what we missed yesterday. Let's check this out. And we talked about this a little bit yesterday, but we didn't get into it. And I guess this is when it comes up. So what was going on is that they were supposed to have some motions like the other day when on Nesto's trial, when they were to do a day of motions, right? So basically I have numerous pending motions, and then this came up, so they tabled it to today, and then they came back in, and it's just like, and then they're asking for a copy of the search warrant, like, what are you guys looking for? The defense is also stating that they didn't become aware of the search warrant until yesterday in court. It was confirmed by Apple, but they weren't notified by the state until yesterday. And apparently this happened like a year ago. So I'm not really sure. Over 2,000. He's been in jail since 2019. So the guy's been in jail since what? He was like 19 or 20 years old. He's 25 now. That's sad. He almost couldn't remember. Like when he asked him how old he was kind of like, okay. Let's see what yesterday. The sound yesterday, I feel like was a bit dicey, but let's see.
Electronically filed October 5th, 2023. Defendant Jamell Demon's motion limiting to exclude certain testimony of Detective Mark Moretti regarding Apple Health Phenomenon. Electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law. Electronically filed October 6, 2023. Response to state's motion to quash and memorandum of law. Electronically filed.
At this moment, the judge is going through a whole entire list of motions that they're going to hear and discuss. And I don't know that even ever happens because they get stuck on the situation with Ravon Liberty, who is the woman who was at the table, and that she is being investigated for witness tampering, a lawyer.
October 9th, 2020. Memorandum Ray, ASA, Christine Bradley testified. Electronically filed October 9th, 2023. Defendant's second motion for redeposition of Detective Mark Moretti. Electronically filed October 29th, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And then ready to have a ruling on the third one.
Okay, well, hold on. Let me get all of them,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Jamell Demon's motion to exclude. Electronically filed November 2nd, 2023. Defendant Jamell Demon's motion to strike the state of Florida supplemental discovery. Electronically filed December 14th, 2023. Defendant Jamell Demon's reply to the state of Florida's response to defendant's motion to strike the state of Florida supplemental discovery list. Electronically filed December 17th, 2023. Objection to business record certification and/or motion in limine. Electronically filed December 18th, 2020. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams. Electronically filed April 15th, 2022. Defendant's request for status hearing. Electronically filed April 15th, 2024. Defendant's motion to set aside stay and/or modify stay to allow discovery to proceed. Electronically filed April 25th, 2024. Motion to compel discovery. Electronically filed May 13th, 2024. Defendant Jamell Demon's motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J. Electronically filed May 14th, 2024. Defendant's motion to strike the state of Florida's motion for rehearing dated May 14th, 2024. That is electronically filed May 14th. And then a defense motion for hearing to determine potential conflict, electronically filed December 27th, 2020. From the state attorney's office, I read the following. State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Killoran from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. That's electronically filed October 10, 2023. State's motion for admissibility of consciousness of guilt evidence and request for ruling prior to jury being sworn, filed October 20th, 2022. State's motion to withdraw State's motion to strike ASA Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed on October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 23rd, 2023. This is not a duplicate. This is an additional document, also filed on October 25th, 2023. State's board memorandum of law, electronically filed October 30th, 2023. State's response to defendant's motion to redepose Detective Mark Moretti, electronically filed October 30th, 2023.
So this article I'm looking at right now, it's almost 6 years he's been in jail. They're saying YNW Melly has been incarcerated for almost 6 years on charges of murdering Chris Thomas, Anthony Williams, his childhood friends, after an alleged recording session in 2018. The case has drawn significant attention in part due to the accusations that Demons attempted to cover up the crime as a drive-by shooting. The first trial concluded in a mistrial 2 years ago in 2023, setting the stage for the upcoming retrial in September. As the situation evolves, another hearing is set for Tuesday morning, which will potentially shape the immediate future of Demon's defense approach. The unresolved status of Liberty's investigation, Liberty is the female lawyer, the black female lawyer, adds a layer of complexity to an already intricate case, stirring discourse on legal ethics and procedural transparency. The pending investigation against Ravon Liberty places YNW Melly in a challenging position as his retrial approaches. The decision taken in the coming days regarding his legal team could significantly impact the proceedings, with the retrial scheduled for September. The focus remains on ensuring a fair defense while legal uncertainties persist. And maybe it's one of these like, okay, he has been in jail for a long time. There was a mistrial. They've kept him in custody and they want to go ahead and get him out of there. One way or the other. He's been in jail far too long. So either he's on his way to prison. Let me see. Okay, let's keep listening. This isn't he's like I said, he's going through the laundry list of motions, but I think it's gonna come up the argument about Ravon Liberty. I'm just curious. So I'm looking on the booking documents, but I wonder, she's under investigation. She just found out yesterday that they subpoenaed or that they pulled her Apple information and that she was just notified that she's under investigation. So I don't know. So the judge ordered that they're to give a copy of the search warrant. So the state said that they weren't going to do it. He said that they must. And that's kind of where it is right now. So
State's motion to strike all jurors for cause with significant knowledge of the previous trial. Electronically filed October 30th, 2022. State's motion for protective order to quash subpoena. Electronically filed October 31st, 2022. State's motion limiting to prohibit defendant from improperly pre-trialing his cause or making misstatements of law during court action. Electronically filed November 1st, 2022. State's response to defendant Jamell's motion to exclude. Electronically filed November 6th, 2022. State's response to defendant's motion eliminating a phone, social media, and business records. Electronically filed November 6, 2023. State's response to defendant's motion to exclude testimony of defendant's alleged gang affiliations. Electronically filed November 6, 2023. State's omnibus memorandum of law in opposition to defendant's motion to suppress evidence. Electronically filed November 6, 2023. State's memorandum of law raised striking jury panel due to defense misstatement of the law. Electronically filed November the 8th, 2023. State's motion to strike the defendant's second motion to dismiss for government prosecutorial misconduct in violation of the defendant's due process rights. Electronically filed November 28th, 2023. State's motion to strike the defendant's unilateral setting of depositions and the state's proposed deposition and motion schedule. Electronically filed December 16th, 2023. State's response to defendant's motion to strike the state of Florida's supplemental discovery. Electronically filed December 16th, 2022. State's motion limiting to exclude testimony of Michelle Boutros and Christine Brett. Electronically filed December 17th, 2023. State's motion to strike the defendant's sworn motion to dismiss. Electronically filed January 12th, 2024. State's response to defendant's objection to business record certification and or motion in law. Electronically filed January 23rd, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation. Electronically filed April 15th, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation. Electronically filed April 17th, 2024. State's response to defendant's motion titled Third Motion to Compel Forensic Images of the Cell Phone. Electronically filed May 20th. I did also today do the state's motion to strike defendant's notice of hearing, electronically filed January 2nd, 2025, as well as the state's response to defendant's motion to compel discovery, filed on May 13th, 2024, electronically filed January 2nd, 2025. As far as previous orders that Judge Murphy entered, I read all of the following. Order denying defendant's motion for redepositioning Detective Mark Moretti, entered August 7th, 2023. Order on motion to remove electronic monitor, entered August 25th, 2023. Order denying defendant's motion to set bond, entered September 22nd, 2023. Order denying defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, entered October 12th, 2023. Order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley, entered October 12th, 2023. Order granting State Attorney's motion to quash subpoena.
I'm going to advance a little bit. I mean, all these damn motions, how are they going to get through all that in 2 days? So now I don't think they're meeting again until February.
The state
I just-
have no reason to doubt their word that she still is under investigation.
Okay, we missed out.
Whenever you're ready, you may proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or not or confidential communications to Miss Liberty, but she has not received any.
That's interesting. So if they took her cloud and they're going through her information, how do we know that it's not a impartial source, like an impartial team, like kind of like the thing that happened with Diddy? And they went through, they searched his cell, they found some things, but it was sent through the filter team. But the filter team still sent stuff to the U.S. attorney, right? Because just because someone has contraband in their cell doesn't necessarily like, oh, we're going to call the prosecutor. So that's a situation that's going on right now. In this situation, if they're trying to find witness tampering, but she has documents, text messages, emails, things like that, and they're reading through things, like he's saying, we could have trial strategy, information, things that's privileged to the defense outside of the search warrant. We don't even know what you're searching for. And you've had this search warrant for a significant period of time. We don't even know what they're looking at. That's interesting, right? This is what I'm reading. Kathy Rusan from Law and Crime tweeted yesterday. She said the state is investigating YNW Melly's attorney, Ravon Liberty, in the related witness tampering case. Melly is accused of getting word to his girlfriend not to cooperate. The state was able to obtain through a search warrant Liberty's Apple Cloud information in December of 23, but they have not notified the defense about any of this. His attorneys are arguing that this could mean Melly might want new lawyers. So this is all very interesting stuff. Let's keep listening. I pulled the documents from both cases, like from the witness tampering and the original murder case. Okay, go ahead.
In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demings, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that's been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009.
I wonder why they didn't tell her straight up and down, okay, we're looking at you. We're aware that there was, I mean, if they feel like they are, that this is really valid and they've got her Apple account, why haven't they just told her straight up, just like, look, you're under investigation. We know how you've been operating with your client, and or we're pulling, however you notify with a defense team regarding a client that you're prosecuting and you feel like there's some inappropriateness going on within the relationship as far as witness tampering, etc. Why wouldn't they just let them know this is to let you know you're under investigation, we've subpoenaed X, Y, and Z? But this is almost like a year later. It's interesting.
In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Deming's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago.
Do you think the state is trying to pull a power move tactic to try to derail his defense team? And because his defense team, there was enough reasonable doubt or something happened where it was a mistrial. I don't know if it was because of the jury. I'm not sure what happened with the mistrial, what caused the mistrial, but why did the prosecution wait until at this moment to tell them that one key member And even if she is under investigation and she does end up with charges, because the conflict would reside within the whole entire team, because we just saw that in the Adelson case. If you guys are following Donna Adelson was going to use Charlie's lawyer. She was using Charlie's lawyer, right? And Charlie, her son, who's been convicted. Charlie is filing for an appeal. Charlie has all kinds of stuff going on. It created a conflict, even though Donna waived her conflict, because Charlie may have been, I'm not sure if he used ineffective assistance of counsel. He used something for his appeal, which ended up getting denied. But because of that, it created a conflict, not just with him, even the second Portia. They're like wrestling on the floor. Because of the conflict of the lead attorney, even the second attorney on the team, because he was working with the other attorney, Roshbaum or something, the whole team had to quit. So now Donna's got a whole new set of lawyers, and literally it happened. The conflict was just kind of like, the conflict was really flushed out like 2 days or a day before trial was supposed to start. Okay. So this is getting a little messy, and not even a little messy. This is very messy. And unless they can clear her and keep moving, it's not going to just be her. It's going to be the whole team. Because, I mean, this is a Florida case, and this just happened in Florida, in Tallahassee, with the Adelsons. I don't know that sets a precedent, but there was other law prior to that, which made it, the judge was like, well, it's the whole team. If it's one, it's going to be all. And the whole defense team, she had to get new lawyers. She thought she was going to be able to take the other lawyer that was already on the case, but because it was already a conflict. You think it's a stalling tactic? The last prosecutor was recused. Interesting. All right, well, let's finish up this little hearing because it's not going to last much longer. 20 more minutes.
We would have sat with Mr. Devins, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Devins' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Devins' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, as a prejudice to Mr. Demons would be monumental that at this late stage, you'd have to get a whole new defense team. So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Miss Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demons on the other side of the glass partition by phone. Have they been tapped? Have they been listened into? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward,
I mean, as an observer, I'm like thinking to myself, they might have to trash this whole thing. They may have to trash it and come back. Lambo, would you stop? They may really have to trash it, and because there's just too much and you can't unsee. So they've been all up in her email, like he said, and like I said before, as far as like the whole Diddy thing with the tank team or the filter team. Has there been one? This is a mess. This is really, and even if they say, like the lawyer is saying, even if they say, well, they're not going to prosecute until after this trial, what has the prosecution now been privy to that you're not privy to? She's been blocked from having confidential conversations as his lawyer, and she's had to go through the box to make phone calls. So these calls have been recorded. They have been, they might be getting monitored. Like he said, they don't know if they're being monitored. Are they listening to their phone calls?
on these other motions that you said,
this is so deep down the rabbit hole. How is he going to get a fair trial?
Go forward as a defense team on any of these motions until we talk.
I almost feel like they think that he's got a, I know this might be conspiracy. This might be like conspiracy corner. But it's one of those like this team was able to litigate to the point that he got a mistrial the first time. Are they trying to throw a wrench, like a monkey wrench, in his defense team and then be in a situation where he's not going to have adequate representation, and the judge is trying to mark a line in the sand and say, we're going to trial on we're standing firm on this date. But if he has to get new lawyers, that's not his fault. That's not his fault.
Talk to Mr. Demons and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with a case I cited to the court, I think all members of our defense team need to call up the Florida bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Demons' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions Mr. Dennis has a lot of thinking to do. Hopefully the court will give us a hearing and some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want to ask? Because I didn't find any authority in that. I don't even know how I would do that.
Well,
Do you have any authority? I understand you're saying that's the judge, this is what we'd like. I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question, the Shanner investigation. And the answer is yes. So the only other question that Rutledge requires is that Mr. Demmons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well, then I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well,
criminal procedure tells me to do. I don't make up things on my own.
then I ask the court, let's go one step at a time. Right now, Mr. Demmons now has been informed that Ms. Liberty is under investigation. And let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demmons needs to know these before, quite candidly, he can make that choice. Now, he can say right now that he wants Ms. Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Ms. Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset?
I do not know how long it will take. Ms. Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight, including Phoenix. She is now on a plane from Phoenix to here. Almost all these motions that you went through are Ms. Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30, but I do think it takes some time for us to talk to Mr. Demmons. She certainly needs to talk to Mr. Demmons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, right, you can't do it. And we need to know, if I may,
Yes, sir.
we need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the tainting whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi, Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called pink team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone said
have.
anything that this has anything to do with Mr. Dennis?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Dennis?
It doesn't.
Okay.
So can you give them a copy?
Why is they're being so secretive? Even if they sent a copy of the copy of the subpoena is not going to have the information about the warrant. So that's why the judge is saying he's ordering a copy of the warrant be presented to him immediately. So the judge today said, bring me a copy of the warrant. The subpoena is just, we need this information. They're not going to tell Apple why. It's just a request, like a requisition or something, right? The warrant is what can yield the subpoena. If there's an active warrant, they can produce a subpoena to the company and say, hey, due to warrant XYZ or investigation, blah, 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 we are issuing this subpoena and we need this information. So, yeah. But the judge is now ordering that it's supposed to come through. So I wonder when we're going to get to see that. But yeah, so they wouldn't say anything about why they're investigating Ms. Liberty. Ms. Liberty might know. And if she's been involved in some shenanigans, then they might be busted. But to this lawyer's point, his defense attorney with the V, with his V haircut back there, I mean, let me stop. I just got distracted by his haircut situation. How deep does this go? They're all, and then how is it that they can take your email, they can take your cloud account and nobody knows, you don't even know for a whole, they got it December 23. So let's just say, maybe, we don't know if this was an ongoing, like we need dumps every 90 days, or was it just this particular point in time? Mimi, you follow me, right? It's this situation right here. That I know I'm off topic now. Let me stop. Okay, but this is very interesting. Okay, let's keep going.
The search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Dennis make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. we can't give anything over until it's
Well,
officially completed.
With all due respect, but this is the high due process part of the state seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right.
It does not have to do with the homicide case.
Well, in any case, he needs to know.
I can't believe she just said that. So the witness tampering is not part of the death penalty case. It's not part of the murder case, but it affects the case because that's his lawyer, dummy. That's his lawyer. So there's a conflict, and the conflict could produce a conflict bleed over to the whole team. I can't believe she's pretending like she doesn't know that. I mean, like, that just happened with the Adelson case. Come on now. Why they were probably trying to speedball to get this tampering. They probably want her off the case. Maybe she's the type, maybe she has enemies at the courthouse and they're like, just go with it. Who cares? You know what I mean? Let's throw a monkey wrench in his defense team. But then they didn't realize, I mean, it's a death penalty. This guy has literally been in jail since he's 19 years old. Now, if he set up his two friends to be killed, then, you know what I mean, he's where he needs to be. But if that's not the case, this guy's been in jail since he's 19. He's 25 right now. This is absolutely, like, wouldn't you want to expedite this to get this case over with?
There is a potential conflict of interest.
Right.
He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy?
And the fact that they've been all up in her email, it's not like, okay, indict already. That's it too. But also they've been all up in her email. So now what has the prosecution seen that could be privileged that they're not privy to? How much information are you guys looking at? Is she under the investigation to the point where you guys are monitoring his visits? It's a mess. This really is a mess. And his lawyers are really bringing up some excellent points. Like, this is bad for him because he may not necessarily be able to keep these lawyers regardless, because now it really is a conflict. And the prosecution pushing this witness tampering, which I know witness tampering is very important, but if the witness tampering isn't as important as the two capital murders, they really could have waited to even set off the investigation, because someone should have thought, you know what, if we investigate his lawyer, that could create a conflict for him to no longer have that lawyer. Now, somebody might have thought, well, that's not our problem. Okay, well, that also would create a conflict for any of the lawyers because they all work together on the case. So if one is corrupt, they're all not corrupt, but if one is corrupted or one person is no longer fit to be, or there's a conflict, they're all conflict.
Copy of the search warrant and give it to opposing counsel.
I'll speak in my office and you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? Defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery of her. She's not a listed defendant yet.
no, let me repeat myself. Mr. Devens has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over, that's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being handed over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two. At
You
minimum.
can decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devens. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant.
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Devens is going to say that's fine. If there's any conflict, I'll waive it, and let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So, how about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30.
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, but we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we will get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions.
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there is a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, for example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not going to file this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal and then, because there's plenty of those to be heard. and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I have not looked at that motion.
Okay, so why don't we do it this way, all right? He's gonna remain on the docket tomorrow. I have a few other matters on both FX and MT, so let's call it 9:30 tomorrow. And, defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, then I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do.
It's the prosecution has painted everybody into a corner. The prosecution has chosen to pursue, and I'm using because I don't know what they did, but this is just I'm hearing this for the first time with you guys. The prosecution has chosen to retry a case. So he's had his day in court. It was a mistrial in 2023, right? Keep in mind there was a whole pandemic that happened, so that probably was a slowdown to the murder trial. Happened in 2019. So then there's the pandemic, there's a backlog, all of the things. He gets his court date, mistrial in 2023. Now it's 2025. He's getting ready to go to trial again, right? 2023, there's some sort of tampering. I've got the tampering affidavit document. It's 27 pages long. It's all kinds of stuff in here. One of the allegations is that he told his girlfriend to not cooperate. I saw something else about some other stuff, some other mess. I haven't even read the whole thing. Because things are on appeal, she's saying that those things can't really be argued because they're on appeal. Then there's an investigation with the lawyer who's actually involved in the case. So that can be a problem because that's going to create a conflict for the legal team, because death penalty cases, you guys already know this from Wade, death penalty cases are automatic appeal. There's no like Sarah Boone, who got life in jail. Well, she'll apply for an appeal. Charlie got life, appeal. Charlie's appeal denied. Sarah just got life in prison, right? Wade got death penalty. He has an automatic appeal. So if Melly were to go for this trial, let's say he were found guilty and he got he would have an automatic appeal. And this is something that could be a problem on appeal because there is a conflict with his lawyers. So someone could say it was ineffective assistance of counsel because his lawyers were not conflict free. If there's a conflict with one, there's a conflict with all. So the team is contaminated. It's like the team would be contaminated, right? On top of that, the defense in general, whether there's new lawyers or not, the prosecution has been privy to not only his case, but multiple cases because Miss Liberty is booked and busy and has other clients. So when they procured her cloud, they got all her information, all her business, right? All her business of her clients. That's another problem. The prosecution has created a situation where it's almost just like the lawyer said, his lawyer, this guy with the V in the back, he needs to go to the bar and do prosecutorial misconduct. This is absolutely ridiculous. It's like almost, I mean, there's what recourses do that? You see how frustrated the judge is getting? Because every time he's even thinking he's got a solution or he offers a suggestion, Melly's lawyer is ready with, well, no, it's going to be this. No, it's going to be that. No, I mean, he's got some really good lawyers. He really does. He's really bringing up every scenario possible, and every scenario possible seems to be something that the damn Miss Ma'am over here, who needs her lowlights and highlights done, doesn't seem super duper prepared to discuss. Yes, Attorney V. Attorney, he's got a perfect V back there and a shiny top head.
State, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in honesty. So we have identified, I think, 4 that we are ready to go on.
Look, the judge is smiling because he's like, okay, you can't stand here in front of me and tell me what Miss Liberty didn't do when you've got a whole investigation and a whole subpoena and everything going on, and you didn't notify the defense that the lead attorney is under investigation and could topple this whole entire case. And you're gonna complain. Look how the judge is looking at her. He almost had a smirk on his face. Like, are you seriously gonna complain about some motion? Like something you're gonna complain about a housekeeping item when you have a blow up the house item?
That we filed responses on. There's no motion filed for somebody's.
You're gonna go to trial. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you. He's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And Judge, we're still asking for proper notice of what we're actually going to hear.
well, I'll take the blame for that. All pending motions. That's why I put that down to the end tomorrow. All pending motions. They're asking for I believe they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title. She's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough.
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today?
Yeah.
Okay, so the FX and FT are both going to otherwise be in recess until tomorrow, which is.
Excuse me.
Yes, sir.
I've been told that Mr. Devens has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT, we're going to recess until then at 8:45 a.m. We'll be off to the good rest of the morning. All right, Mr. Court Reporter, that is it.
Wow. I mean, who knew so much was, and he's got a federal civil case going on. So someone's suing him in federal court. God, for what? I'm going to have to look that up. This guy got a lot going on. My God. This is a lot. This is a lot. So, the murder case is a double murder case. It's a death penalty case. It involves the accusation that two of his childhood friends were killed, and they called it a drive-by shooting, and they're holding Mr. Jamell responsible for the murder of the two co-mates of they were rapping together, and they're holding him responsible for that. So they're saying, okay, so let me go to in 2019, Detective Moretti received confirmation the medical examiner's office. So they were talking about something about Detective Moretti. Okay. Let me get to the part where on October 18th, the search warrant was issued in the case for a vehicle driven by Henry. Y'all, this is 27 pages of affidavit. I really almost would like to read this before so I can kind of just tell you what I read, because I don't think I want to sit and read. This is a long 27 pages. If he had that lined up. I just wonder if the prosecution deliberately, or was this happenstance, coincidental, that they created this drama. Is he capable of making a sound decision? Shaking my head. He needs a new lawyer just to advise him. He should have a separate counsel to come in to just. I'm telling you, when I saw this just happened with Donna Adelson and her lawyer Roshbaum, and they moved up the second chair to be primary. Within a day or two, they realize, oh, he can't do it either. He's not conflict free because of his association with the first lawyer. So she had to scrap her whole legal team. So, and that's in Florida too. Now, the conflicts are different, but it's still a conflict nonetheless. Her conflict becomes their conflict, like a, so anyway, okay, guys. What time is it? Gris, just 1:00. We are early today. Okay. Let me shut this down. You guys asked me about a document yesterday. I'm just gonna tell you guys straight up and down. So it was I really want to shut this down and do a different live, but hold on. I don't mind you coming back later after you read. Oh, yeah, I'm gonna have to read because this is like let me show you guys. This is 27. This is a lot. And then there's redactions, right? So like 27 pages of this. But there's one page. Let me go to page 16 because I'm like, what is all this? Something was going on in the jail. I peeped that. Then there was something about detention search deputy cells. So something about them searching his cells. They've been in his ass, okay? They've been searching his cells. They realized he was talking in some sort of a code. Then there was something over here. Look at this. On Tuesday, April 18th, counsel for Mr. Demons and Assistant State Attorney Christine Bradley exchanged emails about the scheduling of blank for deposition. Ms. Blank was commonly called blank by the defendant is a thinly disguised reference to Ms. Blank. The deposition of Ms. Blank, who's supposed to take place on May 5th, 2023, as evidenced by May 1st, 2023, filing by counsel for Mr. Demons. The deposition did not take place as Ms. Blank did not appear. During the course of the conversations for Mr. Henry tells in custody messengers to slow down, and at times they have to repeat the messages or they describe specific emoji characters or even spells certain words in a particular way. On another occasion, on April 24th, 2023, Mr. Demon again references blank by calling her ASAP Rocky's baby mama. Popular recording artist blank has been in a relationship with another recording artist known as ASAP Rocky. The conversation begins with a message directed to blank, the defendant's mother, tells her to not cooperate with law enforcement in regards to some supposed threats that she reported to counsel for the defendant and the Honorable John Murphy. Ms. Blank subsequently declined to participate in an investigation regarding supposed threats that were made to her. The threats and subsequent lack of cooperation was discussed in open court on April 24th and again on April 25th. The conversation about Miss Blank again mentioned her and told Mr. Henry to make sure ASAP Rocky's baby mama is in the Maybach and she stays that way. Ms. Blank did not appear for the trial of Mr. Demons. Corleen Henry, who is out on bond, has also been confined to his address in Miami-Dade, with the exception of being allowed to leave for short periods of time each week for religious services. During the conversations, Mr. Henry sent out messages via electronic communication. At times, he makes comments such as he cannot type fast enough to keep up with the messages that is being relayed. Detective Garrett Steele obtained the GPS coordinates for Mr. Henry's ankle monitor on April 19th, 24th, 25th of 2023. During each of these days, Mr. Henry seemed within his listed address, including at times corresponding to phone calls with Mathis. The phone calls indicate that Henry is using an electronic means to communicate, such as another mobile device, tablet, or computer from within the apartment. April 19th, 2023, at 19:11:20, inmate Terrence Mathis places a phone call, hold on, and begins to relay the messages. Following exchange occurs with Mr. Henry and Mr. Mathis. Yeah, I need to go through. This is a lot. This is a lot. It's a lot. Baby. I don't think so, because in 2023 I don't think she was even, I don't, God only knows what they're talking about. You know what I mean? They said, I don't know. I'd have to read that again to make it make sense, but we read it off the paper, so I'm not sure what was meant by all that, but baby, it's a lot. Wish you were covering from the trial. You would have a great commentary on his girlfriend's mom's testimony. If and when it happens, that's in September. I love me some Miami, Florida. Okay. I love Florida, period. That would be nice. That would very much be nice. So it seems, you know what? I wonder if I do a control F, can I pull up Miss Liberty? Do they have Miss Liberty's name on here, or do they have her as a Miss Blank too? Let me see. Let me just download it again. Okay, let's see. Yeah, Miss Liberty's name doesn't show up on his booking report. Ravon. Yeah, her name doesn't show up on here. Anyway, this is try and make heads or tails out of it. And they were trying to get Melly's girlfriend not to testify. They were trying to get Melly's girlfriend to not testify. He FaceTimed her right after the murders. Yes, I heard that he was trying to get the girlfriend to not testify. In this, it says that he told his mother to not cooperate with law enforcement. Jamell Demons, what page is this? Page 11. Jamell Demons and Cortland Henry were each indicted for 2 counts of murder in the first degree on February 7th, 2019. Jamell Demons was then indicted on superseding indictment on February 22nd, 2022 for murder in the first degree with a criminal gang enhancement. Mr. Demons has remained in custody of the Broward Sheriff's Office since February 13th, 2019. Cortland Henry was granted bond by the Honorable Andrew Siegel June 1st, 2020, and post said bond June 26, 2020. Mr. Henry violated pretrial conditions and was taken back into custody on April 14th. Or he couldn't even last 3 months, but was granted bond again 10 days later. Mr. Henry has been in court ordered to have no contact with any civilian witnesses directly or indirectly. Mr. Henry, per June 1st, 2020 order, case number, is not allowed to have contact with Jamell Demons. In August 24th, 2021, order was subsequent release and no contact to Jamell Demons was again included, with only exception being in both counsel of Demons and Henry were present. Blank and blank were listed as witnesses of the state of Florida in the initial discovery filing April 9th, 2019, and pursuant to their request, their addresses were not listed, but instead the Office of the State Attorney agreed to accept service on their behalf. Defense counsel for Demons and Henry coordinate the deposition to take place on November 24th and on November 30th, 2021. At this point, they both became uncooperative with the prosecution and were served by investigator Bruce Dowdy of the 18th Judicial Circuit State Attorney's Office. The Honorable Andrew Siegel signed an order to show cause as both individuals, and then on February 23rd, 2022, signed a certificate to produce witness for blank and blank. On November 21st, 2022, blank was located in the U.S. Virgin Islands, where she had traveled under an assumed identity and had a driver's license in her possession that belonged to another individual. The certificate to procure blank was still inactive, and Ms. Blank has not been brought before the court. Blank sends screenshots of an Instagram conversation to Detective Moretti showing that Colteen Henry, while he was out on bond the first time, was engaged in some communication with Miss Blank and Miss Blank, and told Mr. Henry that if Blank told on Melly, he would be getting the death penalty, and that Melly hypothetically told her everything. Miss Blank continued on stating she didn't tell them people what he told her, and there would never be any getting out for him. But since all y'all gunning for her, and she's scared for her life. On April 10th, 2023, the first trial of Jamell Demings commenced before the Honorable John Murphy. The trial resulted in a hung jury, okay? And the case was scheduled for October 9th, 2023 to commence with jury selection. Well, it's now January 2025, okay? Detective Garrett Steele was assigned to the investigation regarding witness tampering in September of 2023. Detective Danny Polo became involved in the case regarding to Jamell Demings February 2022 when contact to review documentation to determine whether or not Demings was a criminal gang member. Separately, Detective Polo had previously conducted an investigation into James Howard under BSO case number. James Howard is currently incarcerated at the Broward main jail and has been in custody in the Broward Sheriff's Office since October of 2020. James Howard is currently being prosecuted by the Office of Statewide Prosecutions for one count of conspiracy to commit racketeering as part of the investigation. Detective Polo periodically monitors the jail calls of James Howard. Each inmate is assigned a particular number and a PIN to access the recorded and monitored jail phone system. Jamell Demings does not have phone privileges due to disciplinary actions while in custody. Detective Polo, while monitoring the calls of James Howard, heard discussions about Howard communicating with Demings and passing messages. These phone conversations then led to Detective Polo requesting in August 2023 Broward County Office Detention Communications Supervisor Kathleen Casey to provide any and all calls from James Howard for the previous 12 months, as well as outgoing to the following phone numbers, blankety blank, 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 blank. Based upon the review of calls, the following information was determined as to who was communicating on the previous phone numbers. Oh, yeah, that Florida is different. Well, now that the calls are in, I don't know. Florida, PCFP are the experts at getting the phone calls. Florida is a tricky state. Once they become part of the trial, then I think they can be pulled. I'm not sure. I've never gotten like phone calls from a jail in Florida, and this guy is an act. Yeah, I don't know. This seems to be like a mess. Um, but I don't know that these are calls that are going to get out until after, it's a capital murder case. Just like with Wade, Wade's calls did not come out until Wade got his guilty, right? Once Wade got his guilty, that's when Wade's calls got released. This is a capital murder or a death penalty. It probably won't be released until after whatever's entered into his case won't be released until after his trial is completed. I can probably tell you that. I don't quote me 100%, but I believe that's what happened with Wade. Wade's calls got released after Wade got his guilty. I think. I don't know. Yeah, because his case was on, it was all over. And once he got that guilty, those calls started dropping. I think is that if that's the timeline. Oh, anyway, guys, I'm going to let y'all go. This is interesting. I'm going to read through the rest of this and try to understand where everything else fits in. I mean, it seemed like they were talking about Rihanna. What Rihanna has to do with any of that, I do not know. Um, I don't think this guy's been in jail since 2019. I don't know. Maybe I don't know. I don't even want to infer anything because I don't really know. In custody messages, slow down, repeat messages. Mr. Demons also references. Yeah, I don't know. I don't know enough about it. I'm sure. Let me just read the whole thing. See what I can understand. They might be using that as a code name. Is that what you're saying, Bella? They might be using that name as a code name. Scheduling deposition, commonly called by the defendant, is thinly disguised reference to Miss Blank. The deposition of Miss Blank was supposed to take place on May 5th. During the course of his conversation, Mr. Henry tells in custody messages, slow down, and to repeat the message and describe a specific emoji and characters. On another occasion, Mr. Demons again references Blank by calling her ASAP's baby mama. So he's using, okay, so it's kind of a code. He's using that as a code. Okay, that makes sense because I'm like, you don't have anything to do with those people. But isn't that awful when your name gets like, how, you know what I'm saying? I know Rihanna's probably like, how did I get involved in this mess? I'm over here making skincare, lingerie, and enjoying my babies, right? Anyway, okay. Y'all, this is an interesting case going on here. So anyway, I'll come back. I need to read some more of this, see what I can surmise out of this, but somehow, so this aspect of the case, this witness tampering, they're alleging, they're investigating his lawyer, Miss Ravon Liberty. Okay. Um, Every time I scroll, it's like, what? Okay. All right, y'all. Hit the like button for me. I do appreciate it. I will see you guys a little bit later. Um, a couple of you guys sent me some other cases. If you want me to, I think I might have a really good lead on pulling some of that paternity information. Do you guys want the middle-aged paternity court information of Mr. Smiley? I'm gonna see. I don't know that Smiley's involved in it, but I think there might be some case information regarding when the paternity tests were or the DNA tests were ordered that ruled out Mr. Nehemiah as the dad, but I'm not 100% sure. I need to pull it and I have a lead about it. So I might just pull it. If you guys are interested in that, let me know if you're interested in that middle age DNA kerfuffle debacle. Thank you, Miss HLS. I appreciate that. Thanks, Pooh. All right, guys, I'm gonna let you guys go. Have a good afternoon. We'll get together again. I'll see you guys later.